Good day to you and welcome to another Paddocks Club tutorial. Today we're going to talk about the rules of natural justice in enforcement procedures in the context of community schemes. So, what are the rules of natural justice in this context? When the trustees or directors make decisions that affect the rights of owners or occupiers, the requirements are fundamentally twofold. Firstly, there must be an unbiased, impartial decision made. The Latin phrase is nemo iudex in sua causa, that is, no one can be a judge in his or her own matter. No member of the decision-making body can have any direct or indirect interest in the outcome of the decision. That's a fundamental tenet. An example, a complaint by a trustee's tenant. The trustee must not participate in that procedure at all. The second, B, I've called it, adequate notice and an opportunity to make representations. That's the right of anyone in a sectional title scheme or a homeowners association. It's called audi alteram partem. You've almost certainly heard of that, and it means let the other side be heard. Now, the no interest is pretty obvious, but let me unpack the notice and the right to make representations. Any person whose rights are affected by a decision or a potential decision must be notified and given an opportunity to be heard. Any evidence or any factor which may count against a person affected by the decision must be made available so that person can, before the decision is made, respond and allow the decision makers to take into account their response in making that their decision. So why are these important? Well, they're fundamental common law rights. The governance documents, the rules or articles of a company, for example, can't contain provisions that exclude owners' rights to natural justice. Taking enforcement steps is hard enough. You've got to be careful. But if the rules of natural justice are not complied with, be careful. That decision can be overturned. So what must you not do? Well, firstly, the HOA directors or sectional trustees must not, themselves or via the managing agent, make a decision that a breach has in fact occurred. That's not a decision you make before audi alteram partem. You must not make a contrary decision. For example, the dogs must go, a penalty or a fine is payable, assuming that that's provided for in the governance documents, or require the person to make any payment, to pay, for example, a charge for a warning letter, unless you have received a complaint, unless you have given the owner the particulars of the complaint in writing and a reasonable opportunity to answer the complaint, including a hearing if this is necessary or if it's requested by the owner. And if the person complained of is a tenant, advised the tenant as well as the owner. These are all the things you must do before coming to a decision. In practice, what often happens? Well, the trustees or directors, sometimes just one of them, might decide that a breach has in fact occurred. Big mistake. And then they'll also decide, oh well, these are the enforcement procedures that must be applied before even giving the owner a chance to respond and to be heard. Trustees and directors might just issue or authorize the managing agent to issue a warning letter, perhaps two, but they'll in these letters say you have breached the rules. First they'll threaten if you don't stop breaching the rules, because you clearly are, then we'll impose a sanction, then finally they might impose the sanction. The dogs must be removed, you must get rid of your tenant, you must take down the fence, whatever it is, but no hearing. Very often there's almost a standard thing that I see in the opinions I do. There are three standard letters. The first is a warning, then there's a second warning, and then third, imposition of a penalty. Sometimes the second and the third letters include charges. These are the body corporate's legal costs, you're going to pay them. The letter refers to sometimes various complaints or several owners, but they give no detail that the owner can argue against. In these circumstances, the owner doesn't have sufficient information to defend him or herself against the complaint, and the trustees appear to have prejudged the owner's breach or his or her responsibility for his or her tenant's breach before the owners had a chance to address the issues raised in the complaint. So, okay, that's what's wrong. What's right? Here's the proper process. The trustees or directors must actually receive one or more complaints from an owner about an alleged breach, or perhaps a series of breaches alleged, giving specific details of the nature of the conduct. The trustees or the managing agent must give the owner the details of the complaint. You've got to show what you've got, show your hand. The trustees must tell or directors must tell the person concerned the dates, the times, the details of the conduct, which means that you can't just complain and say, look, his dog is barking all the time, or whatever. You've got to say, it was on this day for so long. It's important that there be this type of evidence given in complaints. The sections of the Act, if applicable, the governance documents, rules, or articles that have been allegedly breached must be mentioned specifically in the warning letters. The trustees must provide the owner with an opportunity to be heard and to answer the complaint, including a hearing if requested. I don't have any dogs. There never have been any dogs in my unit, and please stop sending me these letters about barking dogs. The trustees, after hearing both sides, must make a decision regarding the complaint. Was it valid? Was it not valid? Was there a breach? Was there not a breach? And if there was a breach, then what are the appropriate enforcement measures? Thank you very much for watching this Paddocks Club tutorial. I hope it's been of assistance to you, and we can talk about any of the implications, which I think are substantial, in the discussion forum. Thank you very much.